Joining us tonight to discuss today's developments, attorney Rebecca Coffey from the Mastantuono, Coffey and Thomas law firm.
Rebecca, thanks for your time today. Prosecutors called Brooks' claim a delay tactic. The judge agreed. Let's take a listen.
I don't think I'm asking something that's impossible for you.
If I can make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results of the test I already took?
But you're telling me you're scared, you're
Yes,
fearful?
I am.
But you don't want to take a test that might tell you today?
Brooks said his results would come back Friday. If he actually does prove to be sick and does have COVID, would the judge be in a tougher position to force a delay? What kind of accommodations would be made potentially?
That's a good question. I think that would certainly be well, this entire thing is highly unusual. I think if that were to happen, the judge would obviously have to evaluate whether he is symptomatic, whether he is competent to proceed both as his own attorney, and then whether he's competent to proceed through a trial, even if he had a representation other than what he is doing himself.
If it ends up that he really is COVID positive, is that enough to have grounds for an appeal later by having the trial be forced to start tomorrow?
I think it certainly would add to the record of the other things that have gone on in this case thus far. It would depend, I believe, somewhat on whether he was actually very sick, whether this was something that he was highly symptomatic at, which he is complaining of symptoms. It's certainly something that the judge would have to evaluate very, very carefully when determining whether to continue on. But I do think it's something that an appellate counsel would definitely look at.
The judge said Darrell Brooks could lose the right to cross-examine witnesses if she says he's too disruptive. How unusual in this really unusual case is something like that? Can that happen?
I have never seen that happen. The right to confront witnesses is a constitutional right. It's a very important and basic right, a fundamental right really that we all rely upon. So I have never heard of something like that happening. Particularly when you don't have a lawyer in the room, either as standby counsel for him or as counsel for him to cross-examine those witnesses, then the jury would not hear any cross-examination then under those circumstances at all.
I recognize you're a defense attorney, but I want to ask you about what all of these disruptions, what did they do, the effect that they have on the prosecution and their preparation for the case? It's
hard for everyone. I really believe that. It's difficult because you anticipate going into trial, you prepare so much, you anticipate and for things that have happened before that you imagine are going to happen again. You always know that there are curveballs, as we say, thrown at you, but something like this, where it's continued daily interruptions and then multiple times a day, I'm sure this is affecting them.
May I ask a procedural question for tomorrow with opening statements?
Yes.
Are those something that the judge or the prosecution can object to if he's going off on a tirade that doesn't have anything to do with the case?
They can. Yes, there are rules. Opening statements are arguments, so the rules of evidence don't necessarily apply, but there are rules still that attorneys, and in this case Mr. Brooks acting as his own attorney, would have to follow.
And on the objections, how does that play out? The stuff we saw today did not have the jury present, and Darrell Brooks potentially in another courtroom. How would that play out when we have opening statements and even witness testimony?
Okay. So with opening statements, if there's an objection, typically what happens is the attorneys appear at sidebar with the judge, which in this case I would anticipate if he's not in the courtroom, either the jury is going to have to leave the room so there can be a discussion. Gosh, it's so unprecedented. I don't know what the judge would do, but those conversations when an objection is made and a judge is ruling on that objection take place outside the presence of the jury. It's very important because the objected to statement or material is objected to because the jury should not hear that. That's the reason an objection is made.
We will see what happens tomorrow. Rebecca Coffey, thank you.